Hi, everybody. I'm Kristen McIntosh, the Happy Lawyer here at Schweitzer and Associates. And today we're going to be talking about estate planning for singles. Our webinar topic is Single and Ready to Mingle with Estate Planning. We're going to be talking about the what, the why, and the how. Stay tuned. But first, a little bit about me. I am Kristen McIntosh, the Happy Lawyer at Schweitzer and Associates. And yes, you heard me correctly. I am happy and I am a lawyer because I absolutely love what I do, which is helping my clients craft unique, personalized estate plans for them. No two estate plans should be alike because no two people are alike. Like I said, I save my cookie cutters for my home baked cookies that I give to my clients, and I don't use cookie cutter estate plans. So let's get into our agenda. Estate planning is very essential for everyone, but for singles or unmarried couples, estate planning is even more important because the sudden death or disability of one partner, if you're living together, could cut the other partner out of critical decisions and jeopardize ownership of shared property and other belongings. So today we're going to talk about who are the singles, why an estate plan, what are these essential documents that you need. But first, I want to talk about some recent trends that are currently trending to bring this whole estate planning topic into perspective. Um, More and more people today are either remaining or becoming single. Many couples are choosing not to get married for a variety of reasons. Some are philosophical. They don't feel like they need to have a ring on their finger in order to have a loving relationship with someone. Others may jeopardize their receipt of alimony or certain government benefits due to the fact that they get married. So currently about 18 million couples are living together without being married. The number of adults aged 50 and older has grown from 2.3 million in 2007 to 4 million in 2016. American adults aged 25 are the largest cohabitating group. Now, divorce rates are also on the rise amongst older adults 50 and older. The rate has nearly tripled since 1990. Once again, is factoring in and let's face it, everybody, we're living longer on average. What that means is that when we do get married, we're more likely to have a divorce in the realm of single. Now we're going to talk about the who. So when we are talking about singles, exactly who are we talking about here? Well, we are talking about, people who have never been married, but we're also talking about people who were divorced, people who are living together with a partner but not married, or people who are widowed. This definition of single, we put it into that, covers a large part of the population. And now we're going to get into the why. So now we know who the singles are. So why is it so important that singles have an estate plan done? Well, we have to think about inheritances, medical decisions, and financial decisions. When it comes to the issue of inheritances, the law automatically presumes that your property should pass to your next of kin. The law does not care, folks, if you like your next of kin or not. So that means if you don't have a will, the law, I always say the state of North Carolina has a nice estate plan in place called the intestacy statute. And that statute will distribute your property if you don't have a will to persons who are related to you by blood, depending on the relationship. So if you're single and your parents are still living, your parents are going to get everything from you, whether or not you wanted your parents to inherit from you. The law also assumes that if you become disabled and are unable to handle your medical or financial decisions, your next of kin should do so for you. Trust me, the last thing you want is for your wishes not to be followed in the case of disability or death. So if you don't have documents in place stating persons of your choosing to make financial and medical decisions on your behalf, then the law is going to kick in and will determine who has the right to make those decisions. And I don't know about you, I'm kind of a control freak. I want to have a say in who's going to be making decisions about my life if I'm not able to do so. So you need to decide who's going to be your decision maker. It's your life. So you should be the person making decisions on who you want to step in your shoes to make financial and medical decisions on your behalf if you're unable to act. You should also be the one who decides who gets the money, property, and other belongings when you die. After all, it was your hard work that earned that money. You should have a say in who gets that property. Now we get into the what. We've established who the singles are and why they need estate planning. So what exactly makes up an estate plan? What do you need? First document we're going to talk about is a financial power of attorney, often known as a durable power of attorney. Now, this document takes place while you were alive, and it covers you in the event that you become incapacitated and are unable to make decisions. For instance, you're in a car accident and you are in a coma, so obviously you can't make decisions on your behalf regarding your finances. Same worst case scenario, if you develop Alzheimer's or a form of dementia, so you no longer have the cognitive skills to make those financial decisions. Maybe you're forgetting to pay your bills, or you're starting to give money to strangers on the street. So that's why a power of attorney is an important document to have in place. In that document, you will choose a person or persons who will make financial decisions on your behalf in the event that you were unable to do so during your lifetime. Now, I always tell my clients, let's just imagine a situation where this could be handy. So, close your eyes. You can close them for just a second or for a thing. And we're going to imagine that you're driving home from work and you're in a car accident. And unfortunately, you end up in a coma. Now, who's going to pay your bills while you're in the hospital? Because you're single, right? So you don't have a spouse who is on a joint account with you who can, start making payments. And better question, who's going to pay your hospital bill? Well, if you had executed a durable power of attorney beforehand, no worries. Because guess what? The agent of your choosing is going to be able to pay your bills for you, because you've already chosen someone to make those financial decisions on your behalf. However, if you did not execute a power of attorney, then someone is going to have to be appointed to make those decisions for you. What that almost always entails is that someone, maybe someone you like, maybe someone you don't like, is going to have to go to court, and they're going to have to file for a guardianship. They're going to have to pay court costs, and they may also have to pay legal bills for an attorney to represent them in the guardianship. And then it's up to a court, some stranger you've never met again, who will make that decision as to who is best equipped to make those financial decisions for you. And again, the court doesn't care if you like the person. You no longer have a say in who's going to make those decisions for you because you did not execute that power of attorney. So get that power of attorney in place. Next document, which is related, is your healthcare power of attorney. Now, this document is different from the durable or financial power of attorney in that a healthcare power of attorney is where you appoint a person or persons to make healthcare decisions on your behalf when you were unable to do so. Now, what do I mean by unable to do so? This means that while you were alive, if at some point you need medical treatment, but your attending physician determines that you don't understand what he or she is saying, you can't communicate effectively with him or her, then somebody needs to step in your shoes and make those decisions for you. Now, which is why it's important to have a healthcare power of attorney, so they can call that person, you get the agent that you've stated that you've already picked, they can call that person, and that person can then make such medical decisions on your behalf regarding your medical treatment. They can look at your medical records, they can talk, get second opinions, consent to various types of medication or surgeries. And the thing to keep in mind with this document, it is a very broad document in the fact that with this document, a healthcare agent can do anything for you regarding your physical or mental health that you could do before, while you were alive, or while you were able to make those decisions on your behalf. Now, don't panic, because there is within that document places where you can rein in that broad authority. Some of my clients already know there are certain treatments I do not want to have taken on my behalf regarding my physical or my mental health. For instance, if you're a Jehovah's Witness, you're probably going to want to state no blood transfusion, since that's against your religion. Likewise, a lot of my clients tend to have strong feelings about not having electroshock therapy. So we put that limitation in regarding their mental health and what the agent can do. Now, why is that so important to have this document? Well, the reason is if you don't have this document in place before you need it, then we already talked about the guardianship, and the same thing. Someone is going to have to go into court and they are going to have to file a guardianship. And again, the court's going to determine who is going to make those decisions. And it may or may not be someone that you want to make those decisions for you. Another reason is due to the Healthcare Insurance Portability and Accountability Act of 1996, also known as HIPAA. Most doctors and other medical personnel are very hesitant to discuss health issues with anyone about the patient unless the patient has given prior permission. Now, I'm not going to say a doctor may not talk to a family member if that family member has not issued or has not already authorized the medical provider to do so. But most likely, in almost a majority of the time, the medical providers are not going to do so due to this act, and your loved ones are not going to be able to, look at your medical records to find out what's going on until a guardianship is in place and a court determines that they have the legal right to do so. Now, I don't know about you, but that's not a situation I want to put my family members in. I want my family members to be able to know what's going on with me and to make the appropriate decisions if I can't. So it's very important that you have this healthcare power of attorney in place. Now, along with the healthcare power of attorney is the living will. Now, this document talks about what life-saving measures should be taken on your behalf if you are in a vegetative state or are unlikely to recover. The living will is also sometimes called an advance directive for healthcare. Now, in this living will document, you get to state, no, I don't want, life-saving measures to be taken in the event that I'm in a coma and the doctors have determined that I never want to, and I'm not going to ever come out of that coma. Or no, I don't want life-saving measures to be taken because I have a terminal illness and there's nothing more the doctors can do for me. So it would just be prolonging my inevitable death. Or worst case scenario, you have an advanced stage of Alzheimer's and your body has reached the stage where it's starting to shut down. And unless they hook you up to a ventilator, your lungs are no longer going to be able to pump to get air into your body. By stating your wishes regarding whether or not these life-saving measures should be taken on your behalf, your loved ones are spared with trying to decide whether or not to authorize life-saving decisions on your behalf. And no, I'm not gonna, say that that's gonna make the decision necessarily easier. But it will help alleviate a lot of guilt and arguments among family members about what you would have wanted. I'm sure we can all remember the Terry Chavo case, and that was a case where Terry Chavo was married. I think she and her husband were either separated or possibly going through a divorce. Anyway, Terry Chavo ended up in a coma, and the doctors determined that for all intents and purposes she was brain dead. So she was in a vegetative state and she was never going to recover from that coma. Now, the husband, she did not have a living will or a healthcare power of attorney in place, unfortunately, and an argument uh, broke out between husband and parents. Terry Chavo's husband insisted, my wife always said if she was ever in a vegetative coma, that she did not want any life-saving measures to be taken, so she should be disconnected from these ventilators, which are keeping her alive. Her parents, on the other hand, were going, no, 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 no. We know our daughter better than you do, and we know that she would want to have every life-saving measure taken on her behalf, so we are not going to agree to disconnect these machines. So what ended up happening was a 20-year legal battle ensued where the parents and the husband battled back and forth over whether or not Terry Chavo should remain connected to the machines that were keeping her alive. A court would decide one way, and then the losing side would appeal that decision, and then another court would reverse it. And it just went back and forth. And in the meantime, it caused a lot of unnecessary angst amongst the parents and the husband. And also, Terry Chavo was just laying there in her hospital bed, and nobody really knew what she wanted. Everybody was just guessing. So you don't want to put your loved ones in that position. So it's important that you execute that living will so that your loved ones will know whether or not you would want life-saving measures taken. And if you don't want life-saving, if you do want life-saving measures taken, under what circumstances. So that brings us so those were all three documents that take place while you were alive. And I always tell my clients, I hope that you will never ever need these documents, but we need to get them in place now while you're healthy, because when the time comes that those documents are needed, it's going to be most likely too late for you to execute those documents. So that brings us to our will, otherwise known as your last will and testament. Now, this document takes place obviously when you pass on, because when you die, if you do have a healthcare power of attorney, living will, and a durable power of attorney in place, those documents and the powers of your agents cease to exist. Instead, if you have a will, then your executor now has the power to act on your behalf in handling your possessions and your financial affairs. Now, if you don't care who inherits your property, then don't make a will. I'll be honest. And when you're married, unlike being single, a lot, if not all of your property and belongings automatically will pass to your spouse, even if you don't have a will. However, if you don't have a will, as we discussed before, the state has already determined who is going to get your possessions. And they're going to follow the statutory line of your blood-related relatives. They're not going to care if you like those relatives. I can't stress that enough. So if you're an unmarried couple without a will, or you're just unmarried, it's a completely different story. If you're an unmarried couple without a will, unless you and your partner jointly own property with right of survivorship, that property is going to pass automatically to your next of kin. The court's not going to care, or the law's not going to care that you were living in the house and you were contributing to the mortgage payments. If you weren't on the deed and your spouse, who is the owner of that home, did not leave that home to you, you could find yourself homeless and out on the street. Not a good place to be. Whereas if you have a will, and your will, you get to specifically, one, state who's going to be in charge of handling your affairs, two, who's going to inherit from you, and three, what the individuals are going to inherit from you. Next, we need to talk about funeral wishes. Now, this is not a typical legal estate planning document, but it's related to estate planning. I know when I do my estate plans for my clients, it's a document that I include for them to complete. It covers everything from what you would want to have done at your funeral, who you want to be notified, what songs you want played, what type of flowers, or if you even want flowers at your funeral, who you want to speak at your funeral. And this just alleviates a lot of family arguments, or arguments between family members and non-family members as to what you may have wanted. Most funeral directors are going to be reluctant to talk about funeral wishes with a non-family member person. So again, if you were living with someone and you're not married, you are probably not going to be able to have a say in the funeral wishes unless your partner had already executed those in writing. So that's something to keep in mind. Another related document to estate planning that's very important to have, especially if you own a home, is life insurance. At the very least, you should have life insurance that covers your mortgage if you do have a mortgage on your home, for the very reason that usually for an unmarried couple, usually people, and same with married couples, you buy a home based on the two incomes. And that's what helps you qualify for your mortgage. So when one person dies, automatically half of the income's gone. And usually, and almost always, the remaining surviving person can't afford to continue making those mortgage payments because their income has now been cut in half. Well, if you had life insurance, then the life insurance kicks in, pays off the mortgage. Now the person, the survivor, keeps the home and now has a home mortgage free. Life insurance, another reason to consider it is it's really not as expensive as you think. There are all different types of life insurance out there. I would encourage you to talk to a life insurance agent to see about what types of life insurance may be applicable for you. Same if you have children, you should have life insurance to cover something, to cover their needs in case something were to happen to you. The advantage of life insurance is, one, you name beneficiaries on your policy. So it passes outside of probate. When the insurance company is notified of your death, they will send a check to the named beneficiaries. So it doesn't have to go through the estate. And the other reason life insurance is a good idea is it's a tax-free gift to whoever you have named as your beneficiaries. So definitely consider that as part of your estate planning. I touched on the word beneficiaries a few minutes ago. Beneficiaries are necessary, especially if you're single. If you have investments, any type of 401ks, Roth IRAs, traditional IRAs, KIOs, any of those type stocks, bonds, make sure you have listed named individuals on those items, because again, those items will pass outside of probate, those proceeds. So it's going to lessen your potential estate tax that you may be liable for down the road. Also, It'll again just be distributed directly to those beneficiaries once the various companies are notified of the death of the policyholder. So good idea. And you want to, once you have those beneficiaries, before I leave this topic, I want to point out that it's very important that, you periodically review your beneficiaries. You want to make sure, one, that you have beneficiaries on all of those policies, and two, you want to make sure that the beneficiaries you have listed are still the beneficiaries that you want to keep on those policies. Had there have been occasions where people have gotten divorced and they forgot to change their beneficiary, and they go on to get remarried and they die. And what happens is the second wife, let's say it was a husband who died, second wife comes in to probate the estate, and then she's shocked to find that all of the investments were in the name of the first wife. And I guarantee folks, the first wife is not going to be generous and say, "Oh, I know you. He intended for you to have all of this $100,000s of dollars. So here, let me just write you over a check." No, she's not going to do that. So don't take the chance. You want to make, and the same is sometimes your beneficiaries may die before you. And obviously you want to replace those beneficiaries if that happens. So finally, you want to talk with a real estate attorney, but especially if you are single and you are not married, you want to make sure that your real estate is properly titled to accomplish your goals for what will happen to the house when you pass on. Some people will have a house that they own in their sole name, and they will meet somebody and they will move that person into their house. So the two of them are living in the house, and then both of them may be contributing to the mortgage, but only one person's name is on the deed. Well, what happens in that case is what we talked about at the beginning of this webinar. If the person on the deed dies first, then and did not have a will, then the house will pass to his or her next of kin, and they're most likely going to want to sell the house and kick your partner out of that house because your partner no longer has a legal claim in that house. Another way you can consider titling your property is to execute a deed with your partner and make you both joint with right of survivor, or joint tenants with right of survivorship. By doing this, that means you both have equal rights in the home. So when one of you dies, the house automatically passes to the remaining person. And then the third way is you can execute a deed where you are both tenants in common. And the difference between tenants in common and a joint tenant with right of survivorship is that a tenant in common, you each have 50, if there's two of you, you each have 1/2 interest in the home. So when one of you dies, you still have your 1/2 interest, but if the person who died did not leave a will, then his or her next of kin will now split that half interest. And that can create a lot of issues down the road. Now, there are advantages and disadvantages to each of these three ownership types that we've discussed. So you definitely want to talk with a real estate attorney before you make a decision as to what's going to be the best for you ultimately. So thank you so much for your time and attention. I welcome any questions. My contact information is listed below. As I said, I am Kristen McIntosh, the Happy Lawyer. Our website is nclegalcounsel.com. My email is kmcintosh@nclegalcounsel.com. And I do thank you for your time and attention here today. We do these webinars once a month, the last Wednesday of every month at 2, and then the last Thursday of every month at 7. And then we do have replays on our YouTube channel. You can see here on the Follow Social Media. We have a YouTube channel where we replay these webinars, and we also post the webinars on our website so you can check out those webinars. The next webinar next month is going to be on pet trust. So if you were a pet lover, you definitely don't want to miss that one. In the meantime, be sure to follow us on social media. Every week, we write a blog and post a related 1 to 3 minute video pertaining to that topic. And it usually deals with real estate, and estate planning matters, as well as matters pertaining to the elderly. So again, thank you for your time and attention, and I will see you next month.